today. I am really excited for this talk specifically because we've had so many questions about California, basically statewide rent control, also known as the Tenant Protection Act of 2019. And, what I wanted to do for this specific talk was get you all an expert in landlord-tenant law to clear up all of the muck really that comes with these kinds of laws that get passed that are very far-reaching. Really, I think this is going to affect almost all of you on the call. I would be surprised if there maybe a couple of you won't, but it's pretty far-reaching. And I think that's why it's so important that we learn from an expert how to go ahead and handle these sort of legislative changes. And the Tenant Protection Act was passed in January, and so there are a lot of things that we need to start doing now, especially there's some deadlines coming up that I'm sure Steve is going to talk about. And just for you guys who don't know Steve yet, Stephen Williams has actually spoken for us a couple of times on the subject of coronavirus. It's been actually really received well with a lot of information that you gave us that really helped us, Steve, especially at the beginning when we were all really confused. So we're really thankful that we have you as a resource, and I'm sure all of you on the call will get a lot out of this, and you'll probably learn some things that you really should know. So with that being said, I'm going to hand it off to you, Steve. We're going to just real quick, we're gonna have you present, then we're gonna do a Q&A, and the full recording of all of this, we're gonna give it to you tomorrow. So go ahead, Steve, and take it away.
Thanks, Alexandra. All right, well, and thank you for having me again to speak to your members. I've been doing quite a few talks lately, and they've all seemed to be focused on COVID-19 and the effect on landlords and property owners, and rightfully so. But it's good to kind of mix things up and talk about something different, and something that's very important as well to landlords, and not really the most exciting topic for landlords. It's a very obviously pro-tenant act or legislation that was passed and became effective earlier this year. Let's just go ahead and sort of parse through it and go over the nuts and bolts of it, and then I think, like Alexander mentioned, we'll have some questions at the end. So I'm going to just go ahead and rifle through it. I'll probably answer a lot of your questions as we go through it, but please, I'll reserve some time at the end so we can go over some of your questions. So let's get started. So this is the Tenant Protection Act of 2019, and it is statewide, all of California, rent and eviction control. And you'll probably hear me refer to it a lot as TPA for Tenant Protection Act. So that's what I'm talking about. So the TPA, Tenant Protection Act of 2019. Let's go ahead and get started. I'm just going to give a little bit of overview. This was signed into law back in the fall of 2019. It went into effect January 1st of this year. Now, there is some retroactive effect of it as well, dating all the way back, I believe it's until in March of 2019. And I'll talk about that as well as we go through this, but just keep that in mind. And the act imposes eviction and rent control on residential properties throughout all of California, even where you don't traditionally have rent controls. Like I practice, I've been doing this now for 20 plus years. I can't believe it's been that long, but for 20 plus years. And I practice in the Bay Area. So we have San Francisco, Oakland, Berkeley, all the traditional rent control jurisdictions and eviction control jurisdictions. So, the concepts and policies of this are nothing new to me and most of my clients. But that's a small group. I mean, we're talking all of California now that is going to be impacted by some form of rent or eviction control. So, stay tuned, and we'll talk about some of the application and exceptions to this law, depending on where you are and your type of property. So one important aspect that I just want to point out to begin with is rental units that are currently covered under existing local rent and eviction controls are generally not affected by this new statewide rent control. So like I mentioned, San Francisco, Berkeley, Oakland, it's really business as usual for those property owners because those property owners have rental units that are already subject to very strict rent and eviction control. And so the Tenant Protection Act is like an umbrella over it, but it really doesn't affect those locally controlled properties. So, and there are a few exceptions, and we'll kind of go over those. And you know, there's a lot of gray areas with this law, and if anyone tells you they know the answer definitively, they're probably, it's probably not true, because I can just, outlay the law and give you my opinions based on my experience with local rent controls for so long as to what I think they mean. But a lot of this is probably, these laws that are being imposed are going to probably have to be interpreted by either the courts or maybe the legislators who pass new laws. And I'll talk about some proposed new laws as well. So just to begin, it's like I said, business as usual for those units that are subject to local rent and eviction controls. So that, but there are some exceptions. So, if your properties are subject to those local controls, stay tuned and we'll kind of go over those as well. So, so the eviction control. So there's two components: eviction control and rent control. So I'm first going to start, right now it's giving a little summary. And so the eviction controls are basically restrictions that require you to have just cause to evict. So essentially no evictions are permitted unless expressly authorized by the Tenant Protection Act. So you have to have just cause. The other component is rent control. So you've got the subset where you can't evict unless you have just cause. And now you've got the subset of rent control where you can't raise rents more than what is permitted under the TPA. And it's essentially 5% plus CPI annually, or it can't exceed 10%. I think in the Bay Area where I live, it was CPI when the law went into effect was 4%. So in my area, it was 9%. Now this will change annually. It's based on the publication of CPI, but initially it was 9% in my area is the maximum increase under the Tenant Protection Act. So the law is set to sunset. What does that mean? Well, after a certain period of time, the law is supposed to be temporary, and after a certain period of time, the law is supposed to sunset or go off the books. Right now, it's basically a 10-year statute that's set to sunset or expire January 1st of 2030. So as of that date, it's repealed. However, you see the little caveat here, not likely. It's very rare, well, eviction and rent control in San Francisco was temporary, and that has never sunset. Same thing with Berkeley, and same thing with probably a lot of the local rent and eviction control jurisdictions. So one thing that we point out here is that no rent law, once enacted, has ever disappeared. So it's probably not going to sunset. It will probably continue beyond 2030. But just be aware that there is a sunset provision. And we do point out one lone exception where a rent law did disappear after it was passed, and that was in Massachusetts way back in 1994. So don't expect things to go backwards here in California with this law. Instead, I fully expect it to be in effect, and in fact, probably be more favorable to tenants as time progresses. But time will tell. All right, so this presentation is really intended to just introduce you to the basic aspects of the TPA and how it is supposed to work. And I say supposed to work again because I can't really predict how it is actually going to work. And there will probably be, like I mentioned earlier, litigation interpreting some of the language that's in this law. So we'll go over all these, and I'll let you know some ambiguities as we go through. The first thing I want to focus on is just cause. So I'm going to talk about eviction control. I'll talk about rent control after, but there's a lot here with eviction control. So basically under the TPA, to evict, the landlord, like I mentioned, must have just cause to do so. If you don't have just cause, can't evict. You have to have a basis to evict. And the TPA sets forth 15 grounds for eviction, just cause. And they're really broken up into two categories. I call them tenant fault, the tenant breaches the lease, doesn't pay rent, or no fault. The owner wishes to move into their own home and make that their residence. That's of no fault of the tenant. So there's several, I think it's about 11 or 12 fault basis for eviction, and I think 3 or 4 no fault basis for eviction. We're going to go over every single one of them. And we'll start with the tenant fault evictions. So tenant fault evictions include, and they're pretty straightforward. And if you live in or around a rent control area, these tend to be pretty comparable grounds that you'd find in a local rent control or eviction control jurisdiction. Non-payment of rent, very basic. Breach of the rental agreement, again, very basic. Nuisance, well, of course, if someone's committing a nuisance, that should always be a ground for eviction. Waste, and I'll define what that is later. And like I said, we're going to go through all of these. Refusal to renew a lease. So, your lease ends, you want to renew it. Tenant refuses, that's a basis for eviction. Criminal activity, of course. Assigning or subletting. Refusal to allow access, when it's permitted by law, when access is permitted by law. Using the premises for an unlawful purpose, again, makes sense. Failure to vacate after termination of employment, and I'll dive into that a little bit more as well. And failure to vacate after the tenant gives notice to the landlord, hey, I'm vacating, and then doesn't vacate. So they give their 30-day notice, but then don't, in fact, vacate. So that's a summary right there of the 11 just cause fault basis for eviction. So tenant fault. So let's go right into non-payment of rent. So the first one, very basic and standard, non-payment of rent. It's important you only include rent. No other money can be included. So you can't include late fees or other costs or expenses under the rental agreement. It has to be rent. These cases will get thrown out of court if you're asking for anything other than actual rent. I still, even to this day, have clients come in and they have served a notice and it includes a late fee. I say, well, you're going to have to start over. So it can only include rent. And as traditionally, as has always been the case, you can give a 3-day notice to pay rent or quit. So there's no extensions on that with the TPA. You can still give a 3-day notice to pay rent or quit. The tenant doesn't pay, that's a just cause for eviction. The rent amount must be accurate. And if it's not, that's a defense, a potential defense to the lawsuit. Now, by accurate, it needs to be the amount due or less. If you overstate the amount, then it could be kicked out of court as a wrongful 3-day notice to pay rent or quit because you're requesting the wrong amount. I've had cases, and this is, again, in rent control jurisdictions, where they have overstated it by a penny. They round up instead of down. And, rather than risk it, I say, start over. I mean, that's how strict it is in where I practice. And I would imagine probably, the same may apply at the state, the statewide rent and eviction control level as well. So anytime you overstate the amount of rent, start over, even if it's a penny. That's my recommendation. The tenant is entitled to raise all their typical defenses of a non-payment of rent case, which the traditional one that I see is breach of the warranty of habitability. So, one of them is the rent's always overstated, or there's always a habitability issue. And that will continue to be a defense to a non-payment of rent case. So all the traditional defenses would apply. So if the unit's uninhabitable and you're demanding the full rent, you may end up losing that case because the value of the rental unit is not equal to the full rent, considering the habitability issues. So that's the first ground for eviction, non-payment of rent. The next one is, again, very standard, breach of the lease. Now, it does have the term material. So traditionally, it's just been a breach of a lease as the basis for eviction under state law. Well, now under the Tenant Protection Act, it's a material term of the lease. What is a material term? Well, it's a case-by-case basis. And you know, I can't tell you right now all the terms that are material, but what you'll see sometimes in rental agreements is an actual statement, this term is material, or an actual provision that says all terms of the rental agreement are material. In that case, I would take the argument that a breach of any particular term is material and would give rise to an eviction under the Tenant Protection Act. Now, one thing I will point out is that if there's a provision of a lease that you deem material that you do not enforce when you become aware of it, the more time that passes, the greater the argument could be. If you're accepting rent and not enforcing that material breach, the tenant could easily argue you have waived the right to enforce it, or it's not material. If you didn't do anything about it to begin with, when you became aware of it, then it could be argued it's not a material term of the lease. So my point there is that if you have a lease violation and you intend to enforce it, do so. Call the tenant on it immediately, or you may forever waive the right to enforce it. The common example I have or see is a tenant brings in a pet. The landlord's aware of it, but doesn't say anything. And maybe a year or two passes, and maybe there's some friction between the landlord and the tenant. The landlord then comes to me and says, "Hey, this tenant has a pet. I want to, that's a breach of the agreement. I want to evict this tenant." And then they tell me the facts. Well, you knew about this 2 years ago. You didn't do anything about it. You're not going to get anywhere in court now. You've most likely waived the right to do anything about it. So that's just one example. So if it's in there, in the lease, and you expect the tenant to comply, then enforce it. Now, here's sort of a wrinkle that's added by the Tenant Protection Act. Historically, before January of this year, when someone breaches the lease, you simply give them a 3-day notice to perform or quit under that code section there, 1161.3. I have a question mark there because what's required now is, and this is one of the ambiguities of this law, is that you first give a warning notice or a notice to correct the violation. That may be in accordance with this 1161. So you give a 3-day perform or quit. You have to give the tenant an opportunity to correct the violation. Thereafter, under the Tenant Protection Act, you can then terminate the tenancy with lawful notice. So what does that mean? That means you give a correction notice first. Okay, the tenant doesn't correct it. Then you give a quit notice. And so what type of notice is it? It doesn't specify under the law. So I've given some examples here. You may give a 3-day perform or quit. The tenant does not comply. Then you give a 3-day quit notice for failure to comply. That's, again, just an example. You'll probably need to consult with your attorney for the appropriate type of notice. But basically the law says for a curable lease violation, you must give a notice to correct or cure, and then thereafter you can terminate. You can give a termination notice. So it's sort of a 2-step process now, and this is all going to play out most likely in litigation at some point. But just keep that in mind. I'm going to talk a little bit more about that sort of requirement to give that initial notice in a little bit later in this talk. So, okay, so we talked about non-payment of rent and now breach of the rental agreement, breach of a material term. The next basis for eviction is nuisance. So when the tenant is maintaining, committing, or permitting the maintenance of a nuisance, that is a ground for eviction. What is a nuisance? Well, it's anything that is offensive to the senses or interferes with free use of property. Offensive to the senses, offensive to smell. Someone's smoking in their unit, and the smell is bothering other tenants. Sound. Someone has loud parties at night, and it's bothering other people. So those are examples of things that are potentially offensive to the senses and may interfere with a neighbor's use of the property. A neighboring tenant, another resident in the same building, is complaining about a tenant who's creating a nuisance by throwing regular parties at night and keeping that person up. That is a basis for eviction under the Tenant Protection Act. Now, again, it's a little unclear as to exactly what type of notice, and myself and my business partner, we have a disagreement on this. So, there's, like I said, going to be some interpretations of this. I think in this circumstance, you can give a 3-day quit notice. And that's, again, authorized under 1161-4, which is tenant commits a nuisance, and, depending on the scope or, the circumstances of that particular case, if it's bad enough, you might be able to just evict with a 3-day notice. However, this sort of circles back to what I talked about with the breach of the lease provision. The TPA specifically has a provision that says for curable lease violations, the owner must first give the tenant an opportunity to cure. So I put that here because, well, the obligation not to commit a nuisance, it's probably a term inside the actual rental agreement. If that's the case, then arguably maybe before you evict the tenant, you have to give this opportunity to cure. And only then, if the tenant continues to engage or repeat the offending conduct, only then can you give that 3-day quit notice. And I don't know the answer to this. My opinion is you can probably get away with the 3-day quit notice without the cure, depending on the conduct. However, as a general practical matter, in my area, when in my Bay Area evictions, when it comes down to a nuisance, I have always strongly recommended you give the tenant an opportunity to cure. You don't just jump right into an eviction for nuisance, because nuisance evictions are tough. You need your witnesses, the tenants who are complaining. There's always going to be some excuse that the tenant who engaged in the conduct has, and there's going to be some back and forth, and the judge or jury may not be inclined to displace someone based on the conduct. You never know. So I usually set up nuisance evictions, or recommend you do so, with some sort of a cure or warning notice. So if you did that, that would certainly comply here, because you're giving that cure before you jump right into the eviction. But again, one of the ambiguous areas of this new law. And so just be aware that it is a basis for eviction. And when you have a tenant who's engaging in nuisance, then you probably need to consult with an attorney to map out the best course of action. And it may depend on the facts or circumstance, or how bad the nuisance really is. All right, so those are the first 3 bases for tenant fault evictions. Next one is waste. The tenant is committing waste. I mean, what does that mean? Well, waste is where the tenant inflicts enough damage to the unit so as to decrease the value of the property. So basically, significant damage. Your wear and tear, maybe things that are a little above and beyond ordinary wear and tear, probably not going to suffice, but some real damage, would likely fall within this category. And the examples that I'll give that may satisfy this are a fire. And I'll just let you know of a real life example I had. This was in San Francisco. It was a fairly new young tenant, just moved in. And I think she'd maybe been there for a month or 2. She was probably just out of college, if I remember correct. Went out, had a night out on the town apparently, came back pretty late, threw some a pot of spaghetti on the stove, and passed out. She was awoken by the fire department, who broke the door down and put the fire that had come about. It was mostly, sort of confined to the kitchen stove area, but it had created enough smoke and enough damage that the fire alarms had gone off and woke up everyone in the building except her. And the fire department came, broke open the door, woke her up, and put out that fire. We immediately evicted, no warning. I think that an example like that very well may be considered, an example of waste, or certainly a nuisance. That was actually the basis that I ended up evicting that tenant on, was nuisance. In San Francisco many years ago, that was a situation where I felt a 3-day quit notice was warranted under the circumstances. Another example, and the cement in the toilet. This is one of the, I don't know if it's an urban legend. I'm sure it's happened. I have never had one of my clients, thank goodness, come to me with that scenario. But you always hear, someone who knows someone who, the tenant, poured cement down the toilet, which would cause, very significant damage. That would certainly, in my opinion, arise to the level of waste and be a basis for eviction under that ground. So again, just to give you a picture, an illustration, significant damage, not your ordinary run-of-the-mill type, nails in the wall for paintings and things like that, or hanging posters and stuff like that. That's not going to suffice. It has to be a significant enough damage to depreciate the value of the unit or property. This is another scenario again where it's unclear what type of notice is required. Is it just a straight 3-day quit notice, or do you have to give this potential curable, advance notice first before evicting? Because again, waste is probably a provision or a term in your rental agreement that the tenant covenants not to commit waste. So arguably a tenant's advocate could argue, well, you need to give this curable lease violation notice first before evicting. Again, I tend to disagree with that, especially if you've got a tenant who's pouring cement down the toilet. I just have a tough time thinking a judge or jury would say, well, yeah, you got to give them an opportunity to cure that. That's probably not a curable violation. But if the damage is curable, then possibly, or the conduct is curable, then possibly you may have to give that sort of advance notice. But again, it's a case-by-case basis, and I would encourage you, if you think that the tenant has committed waste, to consult with an attorney before proceeding with an eviction on that basis. All right, so what's the next one? This is another basis for tenant fault eviction: refusal to renew the lease. So what that means is, you have a 1-year lease. The lease comes up, and you say, all right, it's time to renew the lease. And the tenant, no, I don't want to commit to another year. Well, you can require the tenant to commit to another year. And if the tenant does not and refuses to sign that renewal, then that's a just cause for eviction. But here's the thing: that renewed lease has to essentially be the same lease that they signed in the first place. So you can't throw this new lease with all these new covenants and terms that may run afoul of the Tenant Protection Act. You can't try to get cute with your renewal. If it's a straight renewal and you're just renewing the existing terms, subject to whatever rent increase you're permitted, then the tenant refuses. That's a just cause for eviction. Practically speaking, you're not going to be able to evict a tenant for this ground, most likely. I've been doing this for, like I said, over 20 years. This is also a just cause in the Bay Area for eviction. I have never been able to actually get a tenant evicted for not renewing, because when push comes to shove, they simply renew. Probably not going to be an often utilized ground, but it is some leverage for a landlord to get a tenant to renew if you're inclined to do so. So you want to lock that tenant in for another year. This may be a basis to do that. Criminal activity. So this makes sense. It's a just cause for eviction when the tenant has committed or involved or engaged in criminal activity on the rental property, including common areas, and so or made a threat, a criminal threat to the landlord, and that is a just cause for eviction under this Tenant Protection Act. Now, this is not a just cause, if you can believe it or not, in in the areas where I practice, and it may not be just cause in some of the other rent controlled and eviction controlled jurisdictions throughout California. But there's other potential basis to evict for this type of conduct, like nuisance, for instance. But it's a specific ground for eviction in California under the Tenant Protection Act. And here's an example I'll give that I think would satisfy this. This was a case I had. I think it was in Emeryville, which is in the Bay Area, and maybe it was Oakland. I can't remember exactly, but this was years ago. A tenant was walking to their car in the parking lot, and a tenant and his wife, and he was holding their newborn in a little carrier in his hand. And this is all on video. This is why we were able to act quickly on this. And what happened was they were ready to walk through the parking lot. A vehicle sped through right in front of them, just didn't stop, just missed them. And the father yelled something at the car, to slow down or stop, or how dare, whatever they said. The car stopped. The guy got out, came over, and while the father was holding the baby, punched him in the face, punched the father in the face. That, in my opinion, is obviously a basis to evict. We evicted on nuisance in that particular case, but I think that would probably, satisfy or suffice this ground for eviction. In that case, we gave, the next day we had the 3-day eviction notice out and got that tenant out, and the offending tenant who was driving that car immediately out of the building. So this, just keep in mind, this is a basis for eviction. And again, the obligation not to engage in criminal activity may very well be a term of the lease. So the question again circles back, do you need to give a warning not to engage in this conduct? Well, in my example, how is that curable where he punched the guy in the face? It's probably not. So you may be able to just give a 3-day quit notice in that circumstance. But again, this sort of ambiguous requirement that you give a cure notice for all curable lease violations is sort of looming over all these tenant fault evictions. Does it apply? Does it not apply? And again, it's a case-by-case basis, and that's just something everyone needs to be aware of. And like I said, different lawyers will interpret it differently. And like I said, there's differing opinions between me and my law partner. So let's go on to the next one, which is another basis for eviction is assigning or subletting. That is a just cause for eviction. And I kind of look at this as sort of encompassed in that, material lease violation. Remember, we had that separate cause for a violation of the lease. Well, this is in and of itself a cause for eviction when the tenant has assigned or sublet in violation of the lease. So again, in this situation, it's unclear exactly what notice is required. Under 1161(4) of the Code of Civil Procedure, you can evict without any warning notice for a violation of this provision, of this cause. So for assigning or subletting without permission in violation of the lease, that is a straight basis for eviction, 3-day notice, no opportunity to cure. However, like I said, the Tenant Protection Act does impose this cure notice requirement before evicting, and that probably does apply in this particular circumstance because the obligation to to get consent to assign or sublet would invariably be a term of the tenancy. So if you're going to enforce that, you probably do need to give the tenant an opportunity to cure before you evict. All right, so another one is refusal to allow the landlord access. So as probably most of you know, under Civil Code Section 1954, a landlord has a right to enter a unit for lawful purpose, such as exhibiting the unit to prospective tenants or to workers to make repairs, or entering to make repairs. Those are some examples of lawful reasons to enter. Now, you have to give lawful notice or proper notice before entering, and that typically requires a written notice, hand delivered at least 24 hours before the lawful entry, or at least mailed at least 6 days before the lawful entry. If you've complied with that and have a lawful reason to enter and the tenant refuses access, then that is a just cause for eviction. Now, practically speaking, I wouldn't recommend you evict them for one refusal to allow access. This is also a basis for eviction in the local jurisdictions where I've been practicing for years. And I have brought some evictions on this basis, and they're tough. There always is some excuse. I was sick that day. The tenant said, I was sick that day and couldn't allow access, or I was entertaining and I had people over and it wasn't convenient. I couldn't allow access. There's always some excuse that may be justifiable depending on the circumstances. So I have always strongly recommended that you make repeated efforts to get in and give notice to the tenant that, hey, this is a violation. It's a basis for eviction. Here's your notice to cure. You allow access and then continue to try and get in. If the tenant continues to refuse to do so and allow access, then this is a ground for eviction. And I put here to the right, practically speaking, it's probably not often going to be a basis to actually evict the tenant. Like I said, I've done a number of these throughout the years. It's never actually resulted in an actual eviction issued by the court because the tenant has always eventually allowed access. Kind of like that basis, when the tenant refuses to renew the lease, practically speaking, they'll just renew it when push comes to shove. Same thing here. When it comes down to it, push comes to shove, the tenants generally, to avoid being evicted, just allow access. But again, this could be used as a tool to ensure that you're able to get access when you need to, under the threat of, hey, if you don't allow access, you may be evicted. Cease not allowing access and cure your conduct. And that then could be a basis for eviction if they continue to refuse to do so, but not likely. They'll probably allow access, in my experience. All right, another fault basis. The tenant is using the premises for an unlawful purpose. This is a basis in all the local rent and eviction control jurisdictions where I practice, has been, for years. Some examples of unlawful use may include your traditional drugs, prostitution, gambling. That's not the limit. There are other uses by the tenant may be unlawful as well. Perhaps they don't really live there and instead run their commercial business out of there and have a retail shop in their residential use, in their residential unit, for instance. Well, that would be an unlawful purpose, depending on the codes in your particular jurisdiction. Most likely would be illegal. So, there are other types of use that would be unlawful, and your attorneys can be creative. Depending on the type of use, you may have an angle for a basis to evict on this ground. For years in San Francisco, for instance, when the whole Airbnb thing popped up, short-term renting popped up, that was illegal in San Francisco. It still is to some extent, but that was illegal. And I used this particular ground, which is equivalent in San Francisco, as a basis to evict, because that short-term renting was a violation of the local laws, and therefore they were using the unit for an unlawful purpose. And I was successful evicting on that basis until San Francisco closed that loophole on us. So again, there's the examples I've given here are not all the unlawful purpose grounds, but you can, depending on the circumstances, you may be able to find that some other tenant use is unlawful, and you can evict. And again, under the Code of Civil Procedure, you can give a 3-day quit notice, no opportunity to cure. The question then becomes, well, TPA imposes this additional obligation for curable lease violations of a cure notice. So does that apply in this circumstance? It may, because most likely in your rental agreement, there's a covenant that the tenant not use the premises for an illegal purpose. So again, that cure notice may be required. And again, it really is a case-by-case basis, and you need to consult with an attorney depending on the circumstances of your matter. All right, so we're going through the tenant faults. I think we're about done with them here. This is a ground for eviction when the tenant or employee, in this case, fails to vacate after termination of their license or their employment. This is the typical resident manager situation. So for those of you who have buildings that are larger, containing 15 or more units, there may be a law, or there is a law that requires you to have a resident manager on site. So someone who lives there in the building manages the units for you. So there needs to be a resident manager on site for larger buildings. And typically, and has always been, my strong recommendation is that you have a resident manager employment agreement with that person. Don't just have a rental agreement and then, agree that they'll get, 50% rent reduction for their management. That's not going to fly for a couple of reasons. The first being that probably violates employment laws. But second, they may not be a traditional resident. They may not be a licensee or an employee or an agent in that circumstance, and you may not be able to evict them if and when you terminate their relationship. So, what I recommend is that you have a very comprehensive management agreement, that you have an employment attorney look at that, and you comply with all employment laws, because most likely that manager is an employee. So when you terminate that relationship, that is a just cause under the Tenant Protection Act. And generally no notice is required. Once that termination that employment is terminated, that tenant needs to be out, or that person needs to be out. If not, you can file your eviction action against that occupant. But that being said, look to the terms of that management agreement. Sometimes there will be a notice requirement that's included in that management agreement. Maybe you have to give some sort of a short 3-day notice, or I've seen even 30-day notices that need to be given. But if you do so, and that person is truly a manager or an employee of the licensee, then this is a ground to evict. Now, I have over here to the right, and I put may. This is an occupant that's what I call a tenant at will. Someone who is maybe not a manager or an employee, but instead someone you're just allowing to stay there without any obligation to pay rent. Maybe they're there, they don't pay any rent, but instead they do things around the building. Maybe they are your acting manager. Or maybe it's just a friend you've allowed, or a family member you've allowed to stay there. There's this other civil code section that allows you to terminate a tenant at will with a 30-day notice, because they are not a tenant, but instead they're really a guest, or someone who's allowed with the permission of the owner to be there with no payment of rent at all. And so again, this is a scenario where it may not fall under the Tenant Protection Act, and you may be able to evict in this sort of unique circumstance. The facts and circumstances all have to be, ideal for this type of eviction. But in that circumstance, that might also be a basis for eviction. But definitely, you need to consult with an attorney before giving that sort of a tenant at will 30-day eviction notice, just to confirm that it does not, that relationship does not fall under the Tenant Protection Act. All right, so another one, tenant fault eviction, is the failure of the tenant to vacate after having given notice to vacate. So when the tenant says, hey, here's my 30-day notice, which they're lawfully entitled to do. It's a month-to-month tenant. They have, say they're a month-to-month tenant, they give their 30-day notice to terminate. And then the landlord accepts that in writing. So I accept your termination. You put it in writing. That 30 days comes and goes. The tenant, maybe their other place fell through. They changed their mind, whatever. Well, under the Tenant Protection Act, you can evict the tenant for that refusal or failure to vacate after that period. And no notice is required at that point because the tenant already gave the notice. So the 30 days is up. Let's say they said August 1st they'll be out. You accept it. August 1st they're still there. You can file your unlawful detainer action, immediately thereafter. No further notice is required under this tenant fault for ground for eviction. All right, let me just check the time, see how we're doing. Okay, so I'm going to sort of move things along. And this really is the the substantial portion of the talk is all these tenant fault evictions. The other stuff will move a little more quickly. So we talked about the curable lease violation. So here's what the TPA says is that before terminating the tenancy for just cause for a curable lease violation, the owner shall first give notice of violation with an opportunity to cure under that code section I mentioned, which says, cure or quit. Thereafter, if the violation is not cured within that 3 days, then a 3-day notice to quit without an opportunity to cure may be served to terminate the tenancy. So sort of this is that two-pronged, sort of two-step thing that I was talking about, where you under some circumstances may have to give that opportunity to cure first before you actually evict. So again, we've talked about that quite a bit. So I just wanted to point that out again, just to sort of illustrate specifically what the TPA says on that. So now let's talk about the no fault. We talked about all the fault causes. There's only 4 no fault causes for eviction, and that is owner move-in or relative move-in, withdrawing the property from the rental market, code enforcement issues that require vacating, and demolition or substantial rehabs. So let's dive right in. No fault owner move-in. The first thing I'll point out here is there's a disclosure requirement beginning July 1st in all leases. So I'll talk about that more in a minute. So generally a 30 or 60-day termination notice can be given for an owner or a relative to move in. It's 30 days for tenancies of less than a year, and it's 60 days for tenancies of more than a year. The relatives include spouse, domestic partner, children, grandchildren, parents, grandparents. Note, siblings are not included, so you can't move your brother or sister in under this ground. There are relocation payments required, which I'm going to have a little section on those amounts in a minute. There's no specified duration of time that the person must actually live there. So it's unclear. I'm sure there's going to be some litigation on this at some point. In my area, the laws require a 3-year period to live there, a time frame. So, obviously the longer you live there, the better. But there is no set time. I definitely wouldn't recommend you evict the tenant, move in for a day, and then move out. You actually do need to move in and live there or occupy it. There's no duration of time for move-in either. So the tenant moves out and I move in 2 years later. Probably not going to fly. You need to move in within a reasonable amount of time. The laws here in the Bay Area locally require that you move in within 90 days. So, sort of a rule of thumb, I'd say probably you want to move in within a few months. Type of ownership, I have a question mark here. Let's say John Doe owns the property and they want to move in. Great. What if John Doe, as trustee for John Doe's trust, is John Doe as the trustee an individual, and can that person do an owner move-in eviction? Possibly. I've been doing this for years, and my recommendation is take it out of the trust and put it into your name individually and do the move-in. Once you're in, put it back in the trust. Of course, this could trigger some potential estate planning implications, but that's been my recommendation to evict for owner move-in evictions under local laws. And I may recommend the same thing if someone comes to me under the Tenant Protection Act, if they own the property in their trust. So one thing to note too is that it requires that the owner intend to occupy the unit. It doesn't say reside, or it doesn't say principally live there. It just says occupy. What does that mean? I'm going to probably suggest or recommend my clients, it means you need to live there. You can't just throw a piece of furniture in there and say, I occupy it. Meanwhile, you live in a plush, condo on a suite on the top of a building, you just maintain this for storage or furniture. Probably not going to fly. I tend to think you probably need to actually live there, move in and live there for a pretty significant amount of time. All right, so that's owner move-in. Here's the disclosure for lease. Now, so this is a prerequisite to being able to invoke the owner move-in eviction right, which is for leases that are entered into on or after July 1st, you need to include a provision in that lease specifically allowing owner to terminate the lease for this purpose, for themselves or for their relatives. So most leases now, through some of the various organizations that put leases out, have updated their leases to include this provision. I strongly recommend you do so as well. If you have an existing tenant, it wouldn't hurt to give notice that you reserve this right. It's not required, but certainly for any current leases after July 1st, or any renewed leases. So let's say you have an existing tenant and you renew that lease, stick it in there. So you want to include this provision going forward, just to reserve your right. Even if you have no intent to ever move in, why preclude yourself of that right by not including that provision in your lease? So better to have it than not. Withdrawal of the property from the rental market. Now, this has been a pretty hot topic in local eviction control jurisdictions. There's a state law called the Ellis Act that basically supersedes the local eviction controls and says an owner has a right to withdraw a property from the rental market. Basically, I'm going out of the business. I don't want to rent this property anymore. And you remove all the units within that building from the residential rental market, and local jurisdictions cannot preclude you from doing that. Well, the Tenant Protection Act has a clause that just says, hey, you have the right to evict in order to withdraw the residential property from the rental market. It doesn't specify any duration of time you have to remove it. It doesn't refer to this Ellis Act, which has been around on the books for a number of years. It doesn't specify, what type of a notice needs to be given. Like under the Ellis Act, you have to give a 120-day notice, or even up to a 1-year eviction notice. None of that is specified. So the default is a 30 or 60-day notice, depending on the duration of the tenancy, and that you intend to withdraw the property from the rental market. Again, I wouldn't recommend you do this and then keep it off the market for a day and then turn around and re-rent it. Probably not going to fly. So you do need to actually intend to take it off the market. And my recommendation would be that you actually do for a period of time. How long? This is all going to probably be litigated. But a rule of thumb may be, if you comply with the time period specified in the Ellis Act, you're probably going to be okay, which is at least a 5-year period. But in any event, this is all going to be litigated at some point, I'm sure, or there will be some regulations passed to interpret this. And there are relocation payments required to avail yourself of this type of eviction, and I'll talk about those in a moment. Code enforcement. So, you get your buildings red tagged, or something happens and you're basically you can't rent the property because it's not rentable. It's not in a condition that's allows it to be occupied at the time. By red tag, I mean, the city comes out, the the Department of Building Inspection in your area comes out and says, hey, look, there was a fire. This building is red tagged, or it can't be occupied. So there's basically something that triggers the building not being habitable. In that situation, that's also a just cause for eviction. Now, this is a just cause for eviction in my area as well. Under local laws, you have to offer the unit back once the item or the issue is corrected and the unit is habitable again. Under the TPA, it doesn't say that. It just says this is a ground for eviction. So presumably you could potentially evict without offering the unit back. Now, would I recommend that? It probably depends on the basis for the code enforcement activity. For instance, if it's the result of the owner's fault that the city comes out and says this building's uninhabitable, then yeah, you may consider offering it back. If it's the result of a fire that was caused by the tenant, for instance, I wouldn't offer it back. But so really, it's a case-by-case basis. But the law does not say you have to offer the unit back. So this is a basis for eviction. It does trigger relocation payments, and I'll talk about those in a minute as well. Demolition or substantial rehab. So the owner has the right to demolish the unit or substantially rehab it or substantially remodel it. And that, what does that mean? It can't be some, rinky-dink little remodel. It has to be pretty significant. Basically, substantially modify structural, electrical, plumbing, mechanical, or to abate hazardous materials such that, doing this is going to require the tenant to be out of possession. In that situation, you can give an eviction notice. Again, there's no obligation to offer it back once the work is done. So conceivably, you can actually evict permanently in order to do this. Now, would you elect to offer it back? Again, that would be discretionary and up to the owner and may depend on the circumstances. Permits are needed. So you have to have your permits in order to evict for this basis. And like I said, it can't be merely cosmetic. And there are relocation payments, again, that are required. So I think I'll get into the relocation payments here in a moment. Let's see here. Oh, looks like it's going to be a little slow going here. So let's just pull these all up. So the relocation payments for under the TPA. So this is for all of those elective type, the non-tenant fault evictions that trigger the obligation to make the relocation payments. So the relocation payment amount is an amount equal to 1 month's rent, okay? And you pay it within 15 days of service of the eviction notice. So again, this applies to your owner move-in, withdrawal of the unit or the property from the rental market, code enforcement activity, or substantial rehab or remodel. Those all trigger this relocation payment. Or the landlord can waive the last month's rent, which I think is probably going to be the most prudent thing to do rather than to write a check to the tenant. But so essentially, the relocation payment amount under the Tenant Protection Act is equal to 1 month's rent. The tenant is not entitled to the relocation payment amount if the tenant fails to vacate or the tenant caused the basis for eviction. So that example I gave, maybe the code enforcement activity required the building to be red tagged. Well, maybe the tenant is the one responsible, like they started the fire. Then in that situation, you would not need to make a relocation payment. All right, so let's go on to the next slide here. So exemptions from just cause. We talked about all the tenant fault and the no fault basis for eviction. There were 15 of them. But what are some exemptions from just cause? One is new construction. Buildings that are built within the last 15 years where a certificate of occupancy was issued. So new construction. And I say this is a rolling 15 years. I mean that if your building was built 14 years and 6 months ago it's exempt right now, but in 6 months, it will no longer be exempt because it will be more than 15 years. So it is, a rolling 15 years. So any construction within 15 years is exempt from the just cause. Single-family homes and condos are also exempt so long as they're not owned by a real estate investment trust or a corporation or a limited liability company that has a corporation as a member of that company. And you provide written disclosure. And I'll give you that disclosure in a moment. Owner occupied units with a roommate. So you live in a unit and you have no more than 2 roommates. You can potentially evict those roommates without just cause. Owner occupied duplexes that you principally live in one of the units of that duplex and you moved in before your tenant moved into the other unit, that's exempt. Transient and tourist, so hotels basically, transient use is exempt. Hospitals and elderly care facilities, things of that nature, religious facilities. Dorms are also exempt. Units subject to the local just cause ordinance. So, and I talked about that at the beginning, where I said if your unit is already subject to local eviction control, then it's most likely not going to be covered under the Tenant Protection Act. Instead, it will continue to be covered under that local control. So here's your disclosure for single-family homes and condos that I mentioned. So the following disclosure should be given to existing tenancies before July 1st. We're past that at this point. But what the law says, it must be included in all rental agreements entered into on or after that date, including any renewals of an existing tenancy. So any renewals or rental agreements, you need to include this particular language that's spelled out here that basically says, hey, this is a single family home and is exempt and it's not owned by a real estate investment trust or any of these other entities. If you've given that disclosure or included it in your rental agreement or renewal, again, this triggers July 1st. So keep in mind and put it in all your rental agreements. Any renewal and any rent increase you give, include this language going forward, then you should be okay. All right. So now we're going to go right into rent controls. We talked about eviction controls. Let's talk about rent controls. And what are they? Well, of course, they limit the amount of rent that you can, increase annually. And so the limitations are this. So owners may not increase rent more than 5% plus CPI, not to exceed 10%. And that's over the course of any 12-month period. So annually, you give your rent increase. Now, there is a retroactive aspect to this. If you gave a rent increase in 2019 after March 1st, and that amount exceeded 5% plus CPI at that time, then that rent is rolled back to what the rent was, March 1st, 2019, and not exceeding what you could have given at that time. So it's a little technical. Hopefully that hasn't happened. If it has, there's a rent rollback procedure. You just got to roll the rent back. You don't have to pay the overpayments back to the tenant. The rent is just rolled back for purposes of what your rent, your base rent is effective January 1st of this year. So vacancy control, I mentioned that because once your unit is vacant, this law does not restrict the amount of rent you can charge the next tenant. So that's good. That's very positive. There are some potential laws that seem to be angling toward vacancy control, but under the Tenant Protection Act, once the unit's vacant, you can charge market rate or whatever rent you can command for the next tenant. This only limits rent increases for existing tenants. And again, a written disclosure must be included in the lease or renewals beginning July 1st. So, and I'll give you that language in a minute, or given to existing tenancies. So if you have a tenant that's in place before July 1st, you have a period of time to give this disclosure by August 1st to existing tenancies. And again, I'll show you that language in a moment. The permitted rent increase, again, is calculated based on the lowest rental amount that you charge in any given 12-month period. So if you're giving a rent discount, like you say, hey, look, your first month's free. The rent's $1,200, but I'll give you the first month's free as an incentive to move in. Well, guess what? That rent will most likely not be considered $1,200, but instead possibly calculated at, minus that $1,200 credit that was given, would then potentially, be offset by the $1,200. So you take that $1,200 and multiply it by 11, since they didn't pay 12 for the full year. They had that 1 month free, and then that could potentially, arguably, be your base rent. So, but what it does say is that, if you are giving these discounts, just include that. They need to be specifically set forth in the rental agreement. So any incentives or things like that, they may be excluded from that gross rental rate, but you need to specifically include that into, specifically into your lease. And the master tenant may not sublease for rents that exceed what you're charging. Again, the retroactive aspect back to March of 2019 affects those increases given between March 1st and January of 2020. If you gave the increase, here's the following that applies. The applicable rent on January 1st shall be that rent, like I mentioned earlier, as of March 15th, 2020, plus the maximum amount that you could have given under TPA. So any excess amount would be, wiped out or eliminated effective January 1st. And you're not liable to repay for any overpayment during that period in 2019. So if you increased it by that amount, then the TPA does allow you to potentially, if you increased it by an amount less than what was permitted, potentially you could make that up in 2020 by giving 2 increases this year. But one thing to notice also is that the provisions of the Tenant Protection Act are not waivable. So any language you try to get around the TPA in some agreement, the tenant says, hey, you know what, I'll pay extra. That's not going to suffice. The tenant cannot waive their rights under the Tenant Protection Act. So the Tenant Protection Act will continue to apply, notwithstanding any language you may have negotiated with the tenant that may arguably supersede the limitations imposed. Here's that disclosure. So this is a disclosure that's required for all tenants. Again, it needs to be included. Oh, let me go back. Sorry about that. In all tenancies, or all new tenancies beginning July 1st, or renewals, you need to stick this in there if the TPA applies. It basically just says, hey, this law is, or this unit is subject to the Tenant Protection Act, and it needs to be included as an addendum or in the lease effective July 1st. And if you have an existing tenant as of July 1st, you need to get this disclosure to your tenant before August 1st. So this language needs to be sent to the tenant in a written disclosure, or maybe you can include it as a term of the tenancy by giving a change in terms of tenancy to incorporate it if the tenancy is month to month. But the importance is you need to give this disclosure by August 1st for existing tenancies and effective July 1st for all tenancies going forward. So exemptions from rent control, they're very similar to the eviction control exemptions. Again, new construction, and it's that rolling 15 years. Single family homes that are not owned by one of these particular entities, and that are, that the disclosure has been provided that I talked about earlier. Excuse me, let me take a sip of water. Excuse me. Owner-occupied duplexes, similar to the exemptions from eviction control. Things like Section 8, so something that is subject to some sort of restriction and that would include things like Section 8. Those are exempt from the rent control aspect. Dorms, again, units subject to the local rent controls. Again, so if you've got the local controls in existence, then those will continue to control, not the Tenant Protection Act. And this is that disclosure, again, that I mentioned earlier for single-family home exemptions. Again, you need to get this out, to your tenants, definitely all new tenancies going forward. And it doesn't hurt to get it out now to even existing tenancies, and certainly include it with any rent increase that you give. If this is for single-family homes, if your property is subject, or is in fact a single-family home. So the applicability of the act. So we've covered eviction and rent control. I know we did a little quickly. Let's see. Yeah, it's already, okay, so it's almost 12:15. I'll try and wrap up here shortly so we can go into the Q&A. So there's some other laws that I just want to sort of reconcile here. And that is, local laws and what's known as the Costa-Hawkins Rental Housing Act. And let's go to the next slide. So you've got the Tenant Protection Act, which we just talked about. Well, there's some other laws that may be implicated or that apply to housing, obviously in California. The first being the Costa-Hawkins Rental Housing Act. And for those of you that aren't familiar, that is the law that basically precludes local rent controls from controlling single-family homes under most circumstances, from rent control, or from having vacancy control, meaning Costa-Hawkins precludes local laws from controlling vacant units, meaning once a unit is vacant, the owner can then charge market rate on the next tenant. Now that seems logical to all of you, most likely out there, and it seems logical to me, but those local rent controls, they want to control vacant units, kind of like they do out in New York. Well, Costa-Hawkins says, no, you cannot control under most circumstances vacant units. So those are two very significant components of Costa-Hawkins. Now, local rent controls, and I've outlined several in my area that provide very broad, rent controls. And so you've got the Tenant Protection Act, you've got Costa-Hawkins, which still carves out single-family homes exemptions. You've got local rent controls, and they all sort of interact under some circumstances. And it's confusing. So you've got some contradictions and some overlap. You've got the Tenant Protection Act, Costa-Hawkins, and local rent laws. Local rent laws apply in some circumstances. Costa-Hawkins may supersede those in some circumstances. And then in some circumstances, local rent control doesn't apply, so the Tenant Protection Act applies. So it's very, sort of convoluted, and to sort of navigate what does apply, you should probably consult with an attorney, because there are some carve-outs and exceptions and little things that apply in some circumstances that may not in others. So basically here, local rent control will continue to apply and regulate units that are not affected by Costa-Hawkins. So Costa-Hawkins will still control some of those units. And the Tenant Protection Act will regulate all units in California except single-family homes and condos and owner-occupied duplexes and other units that are regulated by local law. So it's just, again, it's a little confusing. And if you are in a local rent control jurisdiction, this is an area where you need to consult with an attorney to make sure that you're complying with all the applicable laws. So let's sort of predict the future here. So we've got the TPA, and so what's going to most likely happen is right now there's no sort of regulating authority, or there's no rules or regulations to interpret the Tenant Protection Act. So like with most local rent and eviction controls, you've got the ordinances, but then you also have rules and regulations that help implement or interpret the ordinance. You don't have that here. So probably at some point you're going to get those. That, again, at some point in the future. Penalties. Right now there's no penalties imposed for violating the ordinance. But you're probably going to get those at some point. There's probably going to be some change to this that will impose penalties. Litigation. There's going to be a lot of litigation interpreting these laws, and that litigation will result in decisions that interpret the laws. It may also affect units being marketed and rental rates. You know, when units are rented, well, guess what? One of the effects of rent control is that, well, you get as much as you possibly can. So suddenly rents start to rise possibly. I have some clients who say, well, I'm just not going to rent it anymore. I don't want to be subject to this. So units may come off the market, which again may have the effect of rents increasing. And the complexity of eviction. So a lot of these, we talked about all the different bases for eviction. Those are probably going to be litigated, and there will be some interpretations on the rights to evict and some of the procedural requirements. So all these are going to play out over time. The law is still fairly new, and no one's evicting right now at all because of COVID-19 restrictions and court restrictions. So we're not getting litigation on these issues, but at some point we probably will. I want to talk about Senate Bill 1190. This is a proposed bill that will do exactly what I had mentioned, potentially allow a local authority or a government authority to create a local agency to investigate and enforce the Tenant Protection Act. So like a rent board. If you're in a rent control jurisdiction, you're very familiar with the rent board. This will, if it passes, authorize the creation of a sort of like a rent board or a board to determine, to make determinations under the Act, to hold hearings for violations of the Act, to promulgate and enforce rules. Sort of like I mentioned, there may be some sort of a rule that's implemented to interpret or enforce the Act. The Senate Bill 1190 did have the possible imposition of a fine up to $20,000. Last time I gave this talk about 2 weeks ago, that was in the bill. I have been recently told that may have been removed. Again, this bill is working its way through the legislature, and it's not law yet. But I'm told that component was removed. So hopefully, at least the fine component was removed. That doesn't mean at some point in the future we might not see a component of this act with a fine, possibly for violating. So maybe the imposition of a fine. So again, this is just in the initial stages. So it's beyond the initial stage. It's been working its way through for a while. I believe it's gone through a few readings, and it's making its way through, and probably some variation of this will pass, but I don't know. So just something to keep your eye on. Proposition 10. This is a big one. Some of you may remember Prop 10 from the 2018 vote back in November 2018, and that back then was completely abolishing Costa-Hawkins. It did not pass, fortunately. Well, they're back at it again, and I say here, decimate Costa-Hawkins if it passes. It will largely gut Costa-Hawkins, which again, remember, Costa-Hawkins exempts local jurisdictions from regulating or controlling single-family homes, and also from regulating or controlling vacant units. Well, this would eliminate that and basically allow local jurisdictions to control vacant units. So you go to re-rent, guess what? You can't charge market rate. They are putting it, basically saying that they could control or limit it to 15%. So an increase of 15% from the prior tenant. So again, for long-term tenants who are below market, this would be a pretty large blow to the industry. And again, it would essentially eliminate the exemption for single-family homes unless you don't own more than two. So if you have two single-family homes, then you may be exempt. If this law passes, you may still continue to be exempt. But if you own a handful of single family homes, those may all come under rent controls. At least it would open the door for local jurisdictions to control those units. So if you're in a rent control jurisdiction, this Prop 10 is bad news for you. So vote no on that and spread the word. And even if you're not in a rent control jurisdiction, I see this, if this passes, as opening the door for more strict limitations on TPA. So whereas now under TPA you have single family homes exempt, well, they may amend that and say, well, okay, they're exempt so long as you don't own more than two. That again would be a pretty large blow, to the act, because a lot of you may own multiple single family homes. So we're gonna have to see how this plays out in November, and just you need to get the vote out and try to salvage Costa-Hawkins if at all possible. So this does have a lot of steam, and it is something to be worried about in November. So I think with that is the end of it. I'm happy to open it up now, Alexandra, if you're there. Yeah, I see you just popped up. I will go ahead and stop the share here. And so, yeah, I open up. I know we went a little long. I'm sorry about that, but I'm happy to answer a few questions if we have a little bit of time.
Yeah, no worries, Steve. That was all really relevant and necessary information. We've received a lot of questions. I think what I really want to start off with, just reiterating, I am going to provide everyone with the recording. You're all going to get the PowerPoint. And if we don't get to all the questions, which we probably won't today, unfortunately, we'll be able to follow up with you via email, maybe even create maybe some sort of master doc with all of the questions. That would be great. So Steve, just to start off, if you could go back over to that slide where it shows the exemptions to the TPA. I know that was a little bit further back, but I would like to review that because we've received about 5 questions about who is exempt and under what circumstances. And I think there's a little bit of confusion there as to whether or not single family homes are exempt. And also if you're exempt if you live in the home, if you're exempt if it's a mobile home that you're
Okay.
renting out.
Yeah. Okay. Can you hear me? Sorry.
Yes,
Okay.
I can.
Okay. So single family homes. Let's cover this. All right. So single family homes and condos. The actual language is if the unit is alienable separate from title to any other unit, any other residential unit, which has been largely interpreted single family homes and condominiums. You can sell them. Alienable means sellable, transferable. You can sell them separate from title to anything else. So it's a single family home, one residential dwelling unit. Those in large part are exempt so long as they are not owned by a real estate investment trust or a corporation or an LLC that has a member that's a corporation. So generally, your family trust, you own it in your family trust, a single family home, and you rent it to a family, and it is a true single family home or a condominium. That is exempt. If you're mom and pop, you have it in your family trust, or even if you have an LLC, and you and your spouse are the members of that LLC, those are exempt from rent control, and that means exempt from rent and eviction control under the Tenant Protection Act. Now, again, your local laws, if you have local rent or eviction control, that's a different story. You have different laws there. So I definitely, recommend you, check those laws or consult with an attorney in your local jurisdiction if there's, strict rent and eviction control. But just generally under TPA, you're exempt. Now, mobile homes are different. That's a separate area of law. You have the Tenant Protection Act, my understanding is, does not apply to mobile homes. There's a separate area, a whole creature of law that I don't practice in mobile home law that applies to mobile homes. So you need to check those laws. This applies to just your traditional single family homes or condominiums or rental units that are not mobile homes.
Okay, so mobile homes does not apply to that. Okay, the other thing as well, what about a duplex that is in a trust?
So the duplex, so I think I got another slide here. So I'm just gonna not blow them up. Can you see this okay?
Yeah, that's
Or do I need to
perfect,
blow it up?
actually.
Okay.
That works.
Okay, so duplexes are subject to the just cause for eviction. Now, under the TPA. Now, the exception, there's the narrow exception, is when the owner principally resides in the unit and in one of the units and moved in before their tenant in the other unit did. So just because you own so duplexes in and of themselves are not exempt. They are exempt if you own and live in one of the units and rent the other unit and moved in before the tenant in that other unit. So that's the only way that duplexes are exempt.
Okay, that answers that question. Yeah, it gets a little tricky, I think, with the, exemptions there to know if this really applies. And so, somebody's asking, if this is the case, then should they put their condo in a trust or an LLC if that's.
So for a condo, remember, condos again are most likely exempt. Now, putting it in your trust, that is an estate planning tool. So if your estate, if your estate plan warrants or requires, you talk to your estate planning attorney and wants you to put that in your trust, then by all means put it in your trust. Now, some people, for asset protection reasons, want to put properties in their LLC, which again is perfectly fine, and you can do so, and so long as it is not one of the members of that LLC is not a corporation, it will remain exempt as a single family home. Again, for anything more than a single family home, it's covered under the Tenant Protection Act unless you fall within one of these exceptions. And one of them is the owner-occupied duplex. Now, the question for like an owner-occupied duplex, well, if you put that into your LLC, that may be a problem because an LLC can't usually principally reside in a unit. So this is one of those unique circumstances where you need to consult with an attorney. But if you're living in it as an individual owner, or maybe even own it in your trust, and you rent the other unit in that duplex, then arguably that duplex is exempt. Otherwise, if you're not living there, it's not exempt.
Okay. The other questions that I was getting as well is just in regards to, I suppose here, let's see here, just a second. I just moved away from the question. Oh yes, so here's an interesting one. What's considered an extensive remodel for a no fault eviction?
Yeah, and let's see, I think I had some examples there. Let me go back to that slide. Hold on one second here. Yeah, so if that substantial modification is going to modify anything structural, electrical, plumbing, or mechanical, then it's considered substantial. Or if it is to abate hazardous material, and the examples here are lead, mold, asbestos. If you're abating hazardous materials where it cannot safely be abated while the tenant is in occupancy, then it falls within the substantial remodel requirements. So again, the law actually specifically spells out these things: structural, electrical, plumbing, or mechanical, or abating these hazardous materials.
So just to clarify then, if someone wants to get a tenant out and put their rental on the market, and then I guess what they could do is put out a notice that it's going to be put off market. Is that something that is allowable from what I understood?
Yeah, so it is not permitted to, it is not just cause to evict someone because you're going to sell the property. That was not one of the, one of the exceptions to eviction control. So just because you want to sell, that's not a just cause for eviction. So you can sell it with the tenant in there. Now, if instead you wish to substantially remodel the unit before you sell it, then that is a basis for eviction. So long as, again, you trigger one of these things. So you can't come in and say, well, I'm just going to do, rehab, the cabinets in the kitchen, or, do some kitchen rehab that, it's going to make the unit unpleasant while you're there, but it's mostly a cosmetic thing. That's not going to fly. If you're going to go in and make a structural change or some significant, remodel or modification to the property, then that would be a basis to evict. And remember, you do not have to offer the unit back in that circumstance. So you're going to sell it, you want to, remodel it before you sell it. So you ask the tenant to move, the tenant moves, you remodel it, and then you sell it. But just the intent to sell in and of itself is not a basis or a just cause to evict.
Okay, that puts people in a little bit of a tough position, because I think that was an out for a lot of landlords that maybe wanted to retire or finish with, renting their property, and they kind of can't, right? Unless there's a good reason to terminate that tenancy.
That's right. You have to have just cause, and for this particular no fault cause, it has to basically be a substantial remodel. It can't just be something minimal or cosmetic.
There were also a couple of questions sort of not related to rent control about putting parties on the lease. I saw a few people asking about that. So if you live in a house with a roommate, should you have a special kind of roommate lease? And then the other question is, if you have a house with multiple people who are going to be living there, but they're not related to each other, do you recommend having a separate lease for each person, or like one master lease and putting all of them on there?
So the first one is, if you're going to live with a roommate, yeah, I strongly recommend you have a rental agreement with that roommate. And I would even probably, if someone came to me, I would probably even copy and paste that exception from eviction control from the TPA for owner-occupied units where you're renting to 2 or fewer roommates, just so they're fully aware it's exempt from TPA. I would have them sign a rental agreement that has that particular language in there. And so yeah, absolutely, I would recommend that. Now, with regard to having multiple tenants in one unit and having separate rental agreements with multiple tenants, I generally do not recommend that. That is what's known as a almost like a de facto rooming or boarding house. And every local jurisdiction is a little bit different on that. Like San Francisco, for instance, regulates it. They're illegal. So if you do that in San Francisco, it's illegal. Oakland is a little different. I think you can do it there. But again, it creates a potential problem, because let's say it's a single family home and your single family home is exempt from TPA, and you give your disclosure and great, it's exempt. And then you rent rooms. Instead of renting under one master lease to a group of tenants, you rent rooms. Well, one, that may be illegal depending on your jurisdiction as a boarding house. Let's say it's not, and you do that. Arguably, you have now created, let's say you do 4 different rooms and you rent to 4 different roommates and 4 different leases. You have created 4 different tenancies, and there have been some interpretations now under the Costa-Hawkins law interpreting the meaning of a single family home, that you have created 4 units. So you have then now destroyed your exemption from the TPA, arguably, if the analysis under Costa-Hawkins is construed to apply to TPA, which I don't see any reason why it wouldn't. You've now created a 4-plex. Your single family home now is arguably a de facto 4-plex. So there's some reasons not to do that. And plus it makes it a nightmare for someone like me when you come and one of them is creating a problem and you evict that one person. Well, what are you going to tell the sheriff? Go in and remove one person? The sheriff goes in and cleans the whole place out if you have to evict that person. It makes it a nightmare for someone like me to evict just one person, at least in my jurisdictions up here. So I generally recommend one lease for the whole unit.
Okay. So for those of you still on the call, I think I'm going to wrap it up because as we answer one, we get a new one. So suffice to say that this is a very complex topic, and I thank you all for being on the call for this long. I know this is a little bit more than normal, but again, it's something that we all really need to know, especially if you're a landlord in California right now. I think one last thing I really want to wrap up with, Steve, is just asking you real quick how this does affect any of the COVID emergency legislation. Is that something that is counteracting maybe some of these measures?
Yeah, yeah. I mean, right now, courts are shut down for new evictions. So even if you wanted to evict someone now for violating the TPA, you can't get into court. So there's limitations there. Plus, there's local limitations on non-payment of rent evictions, for instance. So every jurisdiction is a little different. And so, like in the Bay Area, you just cannot evict someone for non-payment of rent right now. Just can't do it. Instead, rents are deferred for a substantial period of time. And maybe at some point you could, but right now you can't. And there's also limitations on rent increases. Again, these are all subject to local, and there are some state as well, but local COVID emergency moratoria. So yeah, there are some restrictions right now on the ability to do anything in the landlord-tenant world.
Hmm. Okay. Well, with that said, just be aware of those local laws that are in place. And, thank you so much, Steve. I'm going to follow up with everyone on the call if you didn't see in the chat, again, with the recording, the PowerPoint.
Trouble hearing you,
And,
Alexander? Oh, there we go. I can hear you now.
oh,
I had a little
and
problem here.
I will also be sending over the disclosure. So I put it on a nice little form that you can have the tenant sign. It's the same one that Steve just showed you. And that's going to be two different versions. One if you're exempt, one if you're not exempt. And again, we're going to I'm going to try to describe a little bit again what Steve was talking about the exempt versus non-exempt in like a little follow-up Q&A kind of FAQ doc, because I think that's something that you'll need to look at to determine which of the forms you're going to use and whether this all applies to you. And then I'll also share with you Steve's contact info. So if you have follow-up questions, you can also talk to Steve. I'm getting some thank yous here from Bruce. Good job, Steve. I agree. Thank you so much for your time, Steve. I know this was a lot and I really appreciate it. I'm going to try to share this with all of our California landlords, even the ones who weren't here today.
All right, great. Well, thank you for having me. All right. Thank you, everyone.
Absolutely. All right,
All
everyone.
right.
Have a great day.
Okay.
Bye.